So good afternoon, everyone. My name is Jimmy, and this afternoon we're going to talk about annual leave. I'm an HR consultant here at Root HR, and on the line is Leanne with us as well, who has recently joined us. And so together we're going to hopefully take you through this annual leave session. Now, I should say that this session is being recorded and will be going on our YouTube channel and on our website. Now, there should not be any identifiable information on this, but obviously you need to know about that. There will also be an opportunity to ask questions, and so we would ask you not to put anything in those questions that identifies an employee or share any personal information. Keep it vague, so we cannot track it back to any one person. So with that being said, we'll start our session. So this afternoon, we're going to talk about these following things. We're going to look at quickly the legislation behind annual leave. Then I'm going to look through the basics of annual leave, just the general rules that we all need to be aware of. Then we're going to look at annual leave for part-time and fixed-term staff. And then finally, we'll look at zero-hour workers and term-time only workers. And as I said, at the end, there will be time for Q&A. If you do have questions as we go through the slides, just pop them into the chat, and we'll pick those up at the very end where we do our Q&A. So without further ado, the legislation then. So this is really why we bother. Why do we worry about annual leave? Well, annual leave in the UK is a statutory right, and statutory right is stipulated within the Working Time Regulations of 1998, and it currently gives us 5.6 weeks annual leave. Now, 4 weeks are derived from the Working Time Directive, which, when we were still in the EU, was an EU directive imposed on all EU members at the time, and so it gave us 4 weeks leave guaranteed. And then in 2009, the British government at least, added an additional 1.6 weeks, which brings us to the total that we have today of 5.6 weeks. Now, these 5.6 weeks, often what we see is that bank holidays are included within that. And incidentally, those 1.6 weeks introduced in 2009 are equivalent to 8 days, the same amount of bank holidays that we find in England and Wales. And so a lot of people think that bank holidays therefore are a statutory right, but that's not the case. The legislation actually does not cover bank holidays as a right in itself. But what we do often see is those 8 days are included in the bank into the entitlement. And so really what that leaves us is with 4 weeks leave that people can book at any point they want, obviously subject to permission, and then those 1.6 weeks or 8 days are then reserved for bank holidays, because that's where you may be close. But a lot of organizations don't close on bank holidays, and so it's perfectly permissible to make people work on those days and then for them to use the days elsewhere in the year. Now, another piece of legislation that was introduced in 2015, although it's called the Reduction of Wages Regulations 2014, talks about what the holiday pay should be like if, for example, an employee received bonus, overtime payment, commission, etc. And that was really a result of a tribunal case where an employee said, well, look, I'm receiving all this commission when I work, but when I'm on annual leave, of course, I'm missing out on that commission because I've got no opportunity to actually receive that commission because I can't sell anything while. And so the new rules basically said that if payment forms part of the worker's normal remuneration, so over and above what a standard pay is, then this must be taken into account when calculating holiday pay, as the worker should receive an equivalent payment when on holiday as if they were working. And so we look over a period of 52 weeks, what someone should be earning based on the commissions, bonuses, overtime, if that's a regular occurrence, and then work out what that weekly pay should be like when there are annual leave. And that kind of is quite important because it had an influence on the new rules that have started in July of this year, following the Supreme Court's ruling, which we'll cover a bit later. Now, the basics then of annual leave are these. So a leave year can start and finish at any point, but it's most commonly January to December or April to March. And but most employees will choose maybe January, December to follow the calendar year, or they will use April to March to follow the tax year. But some employees also say, we want to have the leave year mirror our financial year. So maybe run it from October till September. There are even organizations that say that, the leave year starts from the month that you start with us. And so they have different leave years for different people. I wouldn't recommend that. It seems quite an administrative nightmare to me. But if you can handle that, then of course that is perfectly permissible, provided that everyone receives the same amount of leave over a 12-month period. Now, statutory leave for a full-time employee accrues at 2.33 days per month, but an employee doesn't have to accrue leave first in order to take it. So it's very common to see people book an annual leave even though they haven't accrued the leave yet at that point. And that's because we have measures in place that will allow us to recoup any days taken over and above accrued leave if they were to leave throughout the year. And so what we normally say is if someone books leave, they haven't accrued it yet, don't worry about it, allow them to have the leave. We can take care of that if they were to leave by taking out some money from their final salary. Now, when giving notice, it needs to be at least twice as long as the period you book. So that applies to both employees and employees. And after what we see is that's stipulated within the contract as well. And you might deviate from that and asking for bigger notices. But the standard would be double the notice of the period booked. So if you want 1 week off, you need to give 2 weeks notice. And that's more important from employer to employee, because of course that could result in grievances and potentially a claim if you get that wrong. And so, as I said, if you want someone to take leave, you need to give them double the notice. Obviously, you can agree on a shorter notice. So maybe the employee says, hey, look, I could really do with a few days off from tomorrow onwards. Is that okay? If you can make it work, then of course you don't have to say, no, you need to give me double notice. If you can make it work and it's, works for both parties, then absolutely fine. You can have the shorter notice. That's not an issue, and you can apply your discretion. Employees can refuse holiday requests. I mean, it is a request after all, so you can deny or approve it. Absolutely no issue. Ideally for a justified reason. So maybe because someone else is already on leave, maybe it's a busy period. Maybe it simply just doesn't work out that week because you need them to be present in case something happens.
Jimmy.
So
sorry to interrupt. Somebody's reported that they can't hear you. I was just wondering if anyone else is having any issues.
Okay, maybe people can hear us. Maybe put it in the chat just so that we can.
Yeah, we've got a couple saying they can hear. Yeah. Most people can hear.
Okay. I mean, the only thing I can suggest is that the person who can't hear me maybe just leaves and comes back. And maybe that resets whatever setting is preventing them from hearing me. It seems to work for the majority at the moment. Yeah, I'm not sorry. I'm not sure what to. Suggest.
Oh, yes, it's a lady that can't hear. It might be something in the settings that she needs to change.
Yeah. Yeah, I mean, I'm aware from my own experience that the Teams has an issue with particular earpieces, headsets. I just unplug them if they don't work. Because I know I can mess with the settings of the system. It doesn't always recognize the correct port. So yeah, we'll just continue. Hopefully it will resolve itself very quickly.
Okay.
Yeah. Okay, sorry. So as I said, employees can refuse a holiday request, ideally for a justified reason. Employees can also, within reason, stipulate when leave is taken. I mean, think about the bank holidays. Obviously, most employees actually say, we know bank holidays are included into your entitlement. In other words, you need to reserve 8 days of your entitlement for the bank holidays because we're closed on the day. So you can make people take leave. Another reason why you might want people to take leave or stipulate whether they should take leave is because they come to the end of the leave year and they have not taken all their leave just yet. And because I'm an employer, I have a responsibility to make sure people take their leave. You may want to say, okay, if you don't book your own leave, we will do it for you. here is a week's notice, provided that you give them double the notice of that period. So that's absolutely fine. So we can make people take leave if they don't do it themselves, or throughout periods where we close. So sometimes during a Christmas closure, where we close over a whole week, maybe, or over 2 weeks, we can actually ask people to reserve days for those particular weeks where we are closed. Employers should ensure the staff use their statutory leave before the end of the leave year. So it is actually the employer's responsibility to ensure that the employee is aware of their entitlement and that they use their entitlement. And it's very key that we are not seen as encouraging employees to not take it. And sometimes that actually is because we do something nice to the employee, which actually then also encourages them not to take it. So an example here is quite a lot of requests by employees is where an employee might say, well, look, I want to go to Australia next year or America, and I really could do with 4 weeks leave. But obviously, because my statutory leave is not enough, I really could do with carrying some leave over to the following year. If you only provide statutory leave, that's not permissible, because that means you're encouraging them not to take the statutory leave in the current year in order for them to take it in the following year. And we're not supposed to do that. So really, when you pay statutory leave only, they should not be able to carry it over into the following leave year. If you pay enhanced leave, so you pay maybe 5 days over the 28 days, then you can carry over those 5 days, no problems, and you can apply your own rules to those 5 days. But they cannot or should not carry over statutory leave. The exception is where they were unable to take the leave for genuine reasons. So, for example, they were on maternity leave or they were on long-term sick leave. In that case, they really could take it over into the following leave year, provided that was a genuine reason. So, for example, if someone's off for a month, but they have the other 11 months still to take their 5.6 weeks leave, then of course we should try to encourage to do that within those 11 months. But if someone's off for 8 months or 9 months due to long-term sickness, that's probably a justified reason to allow it to carry it over into the following leave year. So, some further rules. If an employee falls ill during or before a pre-booked period of annual leave, the leave is converted to sick pay automatically, provided that they follow the policy, of course. So some employers require employees to provide a fit note for that first week, even though under normal circumstances you might not require that, because normally the first 7 days obviously is self-certified. But you could say, hey, actually, what we want you to do is we want you to get a sick note to show that you actually are genuinely ill for this period. Sometimes other rules are a regular contact with the manager at a frequency agreed between the manager and the employee. Sometimes that frequency is stipulated by policy or contract, whatever it may be. But if they are genuinely ill, then the annual leave entitlement is given back to them and it's converted to sick pay instead. Additional bank holidays, such as the 70-year Jubilee and the funeral of the Queen this year, are generally not an automatic entitlement. Contract wording may be key here. So again, bank holidays are not an entitlement. So that applies to additional bank holidays as well. But where it becomes quite important is whether they're contractually entitled to it. So in the majority of cases where you say, bank holidays are inclusive of your entitlement, then any additional bank holidays declared by the government or by the royal family are not an automatic entitlement to them, because they're already included within the entitlement in general. If they are in addition to your current entitlement, then ideally what I should say is well, your annual leave is X days in addition to the usual bank holidays, because that would then apply. That it applies only to the 8 bank holidays in England and Wales as recognised within the legislation. 8 bank holidays will apply to that, but nothing else. If it just says in addition to the bank holiday or 2 bank holidays, then it becomes a bit more of a interpretation to whether it applies or not. But likelihood from a contractual point of view, they will be entitled as extra 2 days this year. If you were not clear on the fact that it only applied to the usual bank holidays or to the 8 bank holidays. So that's quite key. But again, from a statutory point of view, it's not an entitlement. Accrued annual leave or accrued untaken leave should be paid in the event the employee leaves part way through the leave year. So if they have taken less leave than they've accrued at the point that they depart, you could pay out that leave to the employee. But depending on the word of the contract, you can also ask the employee to take the outstanding leave during the notice period. So some contracts will have a clause in there, most likely under the termination or under the notice clause, that says something along the lines of what you can do with any outstanding leave when they are giving notice. And ideally that says something about the fact that you are allowed to make them take the annual leave during a notice period. If the contract is mute on that, then again, you can stipulate to take the annual leave during the notice period, provided that you give them double the notice of the period they need to take. So if they have 1 week outstanding, you need to give them 2 weeks notice before they have to take that 1 week. And then finally, statutory leave continues to accrue when employees on maternity, adoption, paternity leave, or on sick leave. So when someone is not working but are on one of these leaves, annual leave keeps accruing throughout that period. Now, again, if you pay enhanced leave, then it comes down to policy, because only statutory leave accrues as per the legislation. Any enhanced leave is per your internal policies, the way you allow that to accrue during these periods of leave as well. Right, so how about annual leave for part-time workers and fixed-term employees? So in the UK, there's legislation that protects part-time workers and fixed-term employees from less favourable treatment compared to their full-time permanent employees. In other words, they are entitled to the exact same benefits, the exact same entitlements, and obviously it comes down to pay as well and other great things that come with employment. But obviously it's be proportional to their full-time colleagues. And so it should be prorated based on the days of hours they work compared to their full-time colleagues, and usually use a calculation to work that out. And that's different depending to whether they are fixed term, whether they work part-time, and how they work part-time. And sometimes people work full-time but in compressed hours. So we need to work out different ways of what they're entitled to. But the end result should always be that they are entitled to no less proportionally than their full-time colleagues. If that fails, then it could present itself with a tribunal claim. On the flip side, if you do offer part-time or fixed-term employees a little bit more than their full-time colleagues, that is permissible, because there's actually no recourse for full-time employees to take legal action against that. It may result in grievances, but sometimes you have a justified reason, as we'll see in a minute, to why a part-time employee may get a little bit more or has a bit more favourable terms to their annual leave than a full-time colleague. And the rules of managing holiday pay and request are the same as their full-time employees. Now, instead of showing all the different calculations that we can go through, which there are a lot of, we could just give you 5 examples of what annual leave people are entitled to if they work in different ways. So I've got these 5 examples here. Now, working on the assumption that a full working week is 40 hours, a full working day is 8 hours, and a full working week in days is 5 days, and that they're entitled to the statutory leave only, so 28 days in total. So an employee working 4 days per week at 8 hours per day, what would they be entitled to? Now, you don't have to put it in the chat, you can work it out for yourself a little bit if you want to, but my result would be 80% of total leave, because they work 4 days out of 5, that's 80%. So that'll be 80% of total leave as well that they're entitled to, which is 22.4 days. Now, obviously, applying 0.4 days is not very easy. So legislation provides us with a solution to that. And the solution is that we always round up to the nearest half. So in this case, we go up to 22.5 days leave, which means they get a tiny bit more than their full-time colleagues. But again, that's not a problem, because we can treat our part-time fixed-term employees a little bit better than the full-time employees, for the very reason that we have to round up and for administrative purposes. There is no legal comeback on that. If the result was 22.1 days, we would still go up to 22.5. You're never allowed to round down. It always has to go up, even if it's closer to the full number below it. So 22.5 days. The second example then, employee working 4 days, but compressed hours, 10 hours per day. So they're working 40 hours per week, but over 4 days. What would their entitlement be if we were to calculate their entitlement in days? Well, the result would be, again, 80%, because they're working 4 out of 5 days. But in this case, each day is being paid at 10 hours a day. So they're still receiving 40 hours over the full week, but it's over 4 days, and so they get 80% of total leave of days. If we were to calculate annual leave in hours, it would be the exact same. It'd be 100% of total leave, as if they're full-time colleagues working 5 days a week. It wouldn't matter if we did it in hours, but because we do it in days, it would be 80%. An employee working 30 hours per week. So this is an employee, and we see this actually quite a lot with our clients, where employees don't actually have fixed days they need to work or fixed hours per day. It's very much they need to work 30 hours. Maybe it's a flexi time arrangement. And so they work different hours each day. It's not always the same hours each day. And so it's very hard to work out how many days they actually are entitled to. But what would someone be entitled to if they worked 30 hours per week? What's that percentage of total leave that they're entitled to? Well, the answer is 75%, which equates to 21 days. But as I said, it's very hard to work out in days, but considering they don't work the same amount of hours each day, so what would you pay them for each day leave that they take? It would be okay if they take a whole week, but then how many days do you deduct from that week? So in this case, it'd be a lot easier to actually apply hours of leave, because now every week they take off, we just deduct 30 hours. If they want part of the week off, we work at how many hours they can work in that week, and then whatever hours are remaining are deducted from the total leave amount. So in this case, we see actually that you can apply leave both in days and hours, and sometimes hours is a bit easier due to the administrative needs of working out how much time someone needs to take out when they take leave for a week or half a week or whatever period they take off. The fourth one then, employee working on a fixed term contract with 6 months full time. Well, that's a very straightforward one. They entitled to 50% of total leave, 14 days leave, because they work 6 months of the year compared to their full-time colleagues. So that gets 50% of 14 days leave. That's an oversimplification, because sometimes when you are taking February into account, short a month, are they still entitled to it? They might go slightly up or down depending on what time of the year it is. But from a simplified point of view, it's 50% of total leave at 14 days leave. And then the last one is where they work for 6 months, but at 20 hours per week. So they're only entitled to really 25% of total leave because they work half the year and half the week, which works out to be 7 days. But again, they're working variable hours each day, so it's probably easier to calculate hours, annual leave in hours. Now, I think really what the example shows here is that you can both apply leave in days and hours. It's entirely up to your systems and internal reasoning to what you want to apply. Some organizations just apply hours for everyone, just to have one consistent system. It's entirely up to you. I've used to work with HR systems that would allow me to do both days and hours. And because it was all automated, we didn't really have to worry about the administration that came with that, except that we really were to monitor it. But if you do have an HRIS system, you're usually able to apply both simultaneously, and employees can see exactly what they have left. But again, the key thing here is that they are entitled to the exact same amount proportionally to their full-time colleagues. So what about 0-hour workers and term time only employees? So before July 2022, the practice of roll-up holiday pay was applied commonly to term time only contracts. So a lot of teacher contracts, for example, had this provision that 12.07% was of their annual salary was added in addition to their salary to compensate for the annual leave. And because they would be expected to take annual leave outside term time, it was deemed to be absolutely fine. Proportionally, they would get the same amount of leave as a full-time colleague, even though they work less weeks per year. But because we did a percentage, it worked out really fine. And usually we would also pay that over 12-month equal installments. So they would get 12 months of the same pay regardless. And roll-up pay sums applied to 0-hour contracts, not as common because the legislation in the UK actually prohibited us from doing so. We actually should have never done rolled-up pay, but because it was such a common practice, and because the Court of Justice of the European Union kind of allowed it, because they said basically as long as we do it transparently and comprehensively and it's a genuine addition to the employee's hourly rate, then it can be offset against any legal claim, and that would really provide a very little incentive, if no incentive at all, for an employee to take it to a tribunal. And so up till July 22, especially for term time only contract, that was the practice, 12.07% top of your contract salary to compensate for the annual leave. But then someone took this to a tribunal and it eventually found its way all the way up to the Supreme Court, which we now know as the Harper Trust case, where an employee essentially said, well, look, I'm a term time only employee. I don't think 12.07% is fair. I should be entitled to the 5.6 weeks as well, just like my full-time colleagues. And the Supreme Court eventually ruled in her favor. And so that means that right now, people who work on a term time only contract, but is on a permanent contract, so it goes from year to year, are entitled to 5.6 leaves as well. Those who you employ only for 1 year in term time would be considered a fixed term contract. That in itself doesn't fall under this new rule. So if someone you appoint only for 1 year on a term time only contract, then the rule does not apply. However, and this happens quite a bit at the moment, where we see 1 year contracts being applied and renewed each year. I mean, if that happens and there is no genuine gap in employment, even though they're 1 year contracts, it will be considered continuous employment, or at least it will be likely considered to be continuous employment. And in that case, we would say this rule applies as well. So an example would be where a contract may run from September till the end of July. The contract ends the end of July. And at that point, you say to the employee, well, look, we've got no work in August for you, obviously, because we're closed. But from September onwards, here's a new contract for the following year. It'll be another 1 year contract. Because you are giving a guarantee of employment at the point of the original contract ending, there is no genuine gap in employment. And as far as the legislation is concerned, that would be continuous employment. And so the 5.6 weeks would apply in that case as well. So essentially by applying a single year contract, year on, year in, year in and out, it doesn't actually save you from this ruling. It only applies if there is a genuine single year contract for term time only. And that means essentially that we have to add 5.6 weeks leave to the amount of weeks that actually are working. So if a term time employee is only 38 weeks of work, then we add 5.6 weeks to that contract to compensate for the annual leave. We can still ask them to take leave outside term time, but a 5.6 weeks needs to be added, and it's at the weekly pay that they will receive throughout the year. Now, the implication of this was that it also affected those working on 0-hour contracts, both employees and workers. And the reason for that is that like term time only contracts, 0-hour contracts don't always work the full 52 weeks. And so we've always worked on the premise of, we look at how many hours someone's worked over a month. We then apply 12.07%. That gives us the total amount of hours that they've accrued in annual leave, and we'll pay that in the following month's pay, and then tell them to book annual leave on the days they're not supposed to work. And again, that was perfectly fine before July 2022, but now we have to follow this rule where they are also entitled to 5.6 weeks leave, because a 0-hour contract is often continuous. It doesn't actually have an end period. Again, if it has an end period, it might be slightly different. We can do pro rata, but if it's a continuous contract, this rule 5.6 weeks applies as well. And in the ruling, actually, a contradiction was raised in that what happens if someone only works, say, 3 weeks a year, and the response was that the 5.6 weeks would apply in that case as well. And the 5.6 weeks is based on an average weekly pay, which we'll cover in a bit. The important thing here is that if someone on a fixed term contract leaves throughout the year, then obviously we'll still prorata that element then, so the 5.6 weeks will be then prorated to that, to the amount of time they've actually worked compared to the contract. So if a fixed term contract leaves throughout a year, it will be the same rule as if someone was permanent contract, full-time, 52 weeks kind of in a year working. It will be prorated at that point. So that's the same rule as we saw earlier. Now, as I said about the pay, 5.6 weeks of pay, the average weekly pay. And to establish the average weekly pay, we need to look at the previous 52 weeks where an employee worked. So we need to look at a 52-week pay period where an employee worked. What that means is that if we look at the previous 52 weeks and there are 8 weeks in that year where they did not work, we have to skip those 8 weeks and find an additional 8 weeks beyond the 52 weeks, but up to the point where we have a full period of 52 paid weeks. We take an average of that, and that average is what we need to pay the employee when they book leave at that very point in time. And so obviously that presents an interesting issue, because obviously now we need to go into our records. We need to make sure that we keep records of weekly earnings, so we can keep an absolute accurate record of average weekly pay. And ideally, you will run a system that will do that for you automatically, so that by the time someone books leave on a 0-hour contract, you can just pull up the figures of what they should be receiving in that week. If a worker is engaged for less than 52 weeks, then you calculate the average over the period worked, again, excluding any weeks where they did not work. So if they've only been with you for, say, 26 weeks, and they didn't work 4 out of those 26 weeks, then the average pay will be over 22 weeks paid. And then you pay them the annual leave in that way. So that's kind of the basics of what that ruling means. So to kind of recap on that quickly, if someone is on term time only, and it's a permanent contract, so year on, year out, so they work from September till July, but then they are engaged again in September, and that's a continuous employment, they will be entitled to 5.6 weeks on top of their weekly working week. So if it's 38 weeks, they'll be entitled to 38 plus 5.6 weeks. If someone is working variable hours or on a 0-hour contract, and again, it's continuous, then we need to work it out over a 52-week average pay, where weeks are excluded where there was no pay until we have 52 weeks, or if someone has been working for you less than 52 weeks over the period that they've been working with you, again, excluding weeks that did not work. Just finally, to keep things in mind before we go to Q&A, bank holidays, recognized bank holidays are not a statutory right to have it off, and employers can ask staff to use their entitlement to book a day off if closed, for example. 5.6 weeks applies to permanent employees as well as term time and 0-hour workers at average weekly pay. Carryover, statutory leave should not be carried over unless the employee was unable to take it due to long periods of illness or maternity leave, for example. Again, enhanced leave can be carried over and needs to follow your own rules. And to make sure that your part-time and fixed-term staff have an equal proportion of leave, to ensure that you don't get any legal claims coming your way or grievances. And that's really annual leave in a absolute nutshell. So I'm going to turn over to Leanne, who may have collected some questions from you during this session.
Yes, we've got a few questions. The first one, is it a good rule of thumb to not carry forward any days to the following year?
So statutory leave should not be carried forward anyway. So you can tell employees that that cannot be carried forward. And, you know, even if an employee asks for it and you can facilitate it, you shouldn't do it, because we're not supposed to be seen as encouraging people not to take the annual leave in a given year. So from a statutory point of view, no. But if you offer enhanced leave, then again, it's entirely up to you to whether you want to set up rules about moving that forward into the following leave year. What I would do in that case, if you have enhanced leave, is to say, well, look, if you carry forward any enhanced leave, you need to take it before this date, and usually like a 3-month period in which they have to take that additional leave. Because otherwise, what you run the risk of is that they start accruing loads of annual leave, and then they get to a point where they want to book it all, and you can't facilitate that. So yes, I would put some very strict rules on carrying forward enhanced leave, just to manage that from spiraling out of control.
Okay. Do you have a holiday calculator that is accurate to support pro rata calculations? And if so, can we send it over?
Yes, we do. Well, we're actually working on it. but what I will do is we'll get the list of people that have attended today, and we'll send you over that calculator so you can use that. What I would say is if you pay statutory leave only, so the calculator is very useful if you pay enhanced leave as well. But if you pay statutory leave only, the gov.uk calculator is very accurate because you just put your details in and it gives you exactly the amount of statutory leave that a person is entitled to. So I'll send that link over as well to everyone that participated today. But we also sent our calculator over because quite a lot of people that we know of offer enhanced leave as well. And of course, the gov.uk calculator doesn't take that into account. So yeah, so we'll send it over.
Okay. What happens with the rounding up if we work in hours for annual leave?
Yeah, so I mean, so the result can come out in hours or days. It doesn't really matter which one it is. But if you get to a strange rounded number on hours, then again, you always round it up. And the reason why you always round it up is that because if you round it down, then of course you're offering either less than the statutory amount or less than the full-time colleagues. And that is a problem in itself, even though it's only maybe by a fraction. And so you should always round up, whether it's hours or days.
What is the full-time hours? So does that depend on the company, what they set as their full-time hours? Or is there a standard amount?
No, I mean, full-time hours is entirely up to the organization. Some are 35, some are 40, some are 37.5. I mean, from an annual leave point of view, it doesn't really matter because obviously, well, it matters for the purposes of calculating whether, what someone's entitled to proportionally. But the statutory amount is 5.6 weeks or 28 days. And obviously you can work it out per hours. And the way you work it out in hours is to say, okay, well, if we have a full-time week is say 37.5 hours, then we know that each day is 7.5 hours. And so, if we're entitled to 28 days, then I multiply 28 by 7.5. Now I know what my entitlement is in hours. And so then if someone comes in at 20 hours a week, I can just take the proportion of that. So I can say, well, the proportion of 20 parts of 37.5, I don't know what the percentage is, my math is not that great, but use a calculator, and then whatever percentage comes out of that is the percentage they'd be entitled to the total hourly annual leave that you just calculated. So that's how it would work. But what your full-time weekly hours are, that's entirely an internal decision. There's no legal guidance on that. But as I said, it's usually between 35 and 40 hours a week.
Okay. Regarding part-time staff working 3 days a week, bank holidays are normally on a Monday. So if you work on a Monday, you would have less annual leave balance than somebody working midweek. So is it best not working on a Monday, and bad luck to those who do?
So there's two ways around that. So obviously the entitlement would always be the same. I mean, you're right. If you close on a bank holiday and someone works on a Monday and a Friday, they're going to be very unlucky because they're going to have to reserve quite a big part of their portion of leave for the bank holidays. Now, there's two ways around that. One is to say, okay, well, look, can we be flexible in how we apply in that week? So if someone works always on Mondays and they don't work on a Tuesday, could they work on a Tuesday instead, for example, so they can reserve that day for elsewhere in the year? That's one way around that. I wouldn't necessarily restrict yourself in saying, well, we're not going to hire employees on a Monday or a Friday if they're part-time, because that would not be fair. It's kind of tough. That's just the way it is. You're closed. That's the way it is. But as I say, you can be a bit more flexible because they can work in different days in a week if both you and the employee agree. And then that way they can bank those days for elsewhere in the year.
Okay. Due to the recent added bank holiday, 19th of September, we gave staff an extra day annual leave. As part-time employees like myself accrue it pro rata, adding into my annual leave gave me 0.5 days, but I had to take one full day, which means I've lost 0.5 days. Is this correct under employment law? It feels like part-timers are at a disadvantage. Would we have preferred to work, but the office was closed?
Okay. I mean, from a legal point of view, all the employer has to do is to provide you proportionally what a full-time employee was getting. So if you work 50% of the week compared to a full-time colleague, you'll be entitled to 50% of a full day. So from that point of view, they've probably done the right thing. And the fact that you have to take a full day because they were closed that day, it really comes back to that question of, if someone always works on Mondays, is that fair? It's kind of the way it is. There is no other way around that, except of course if you can both agree on working on a different day. But the employer is not they're not obligated to accept that. They can say, well, no, we don't do that because we don't need you on a Tuesday or whatever day that could be an alternative day. So to answer your question, from a legal point of view, all they had to do was give you the proportion of that day compared to a full-time colleague. They didn't have to give you the additional half day. There was no obligation on the part of the employer to do so.
Okay. If an employee leaves halfway through the year and they have used more annual leave than they have accrued, do they have to pay it back? And if yes, can an employee deduct it from the final pay slip, or do they have to request it's paid back?
Okay, I mean, ideally, that it's something in your contract that would stipulate that if someone's taken too much annual leave, you can recoup the equivalent amount from that final pay. And that's what most employers do. They will look at the annual leave. You work out how much annual leave they've accrued versus taken, and if you find that the balance is in favor of the employee, in other words, they've taken too much leave, then yes, you can take that. You can take the equivalent out of final pay. But what I would always make sure that I do is, one, is that ideally it's in the contract. Two, I would always inform the employee at the point that they give me the notice. So when they give the notice, I would work out immediately what the annual leave entitlement is, the final pay, etc., so that they are aware that come in 4 weeks, 2 months, 3 months, whatever the notice period is, that final paycheck is going to see a deduction to compensate for those days.
Thank you. What if you currently run payroll calendar monthly, so you don't have weekly information?
I'm assuming that refers to the weekly average pay. So
yeah,
we're still supposed. I mean, from a legal point of view, again, we have to actually keep track of employees working out, whether they're full-time, part-time, 0-hour workers, term-time only. We're actually supposed to record people's working hours. Now, the vast majority of employees don't do that because we're just working on a kind of trust basis. But actually, especially for 0-hour workers, where the hours are variable each week, we should have a record of how many hours they work each week. And so really what it comes down to is you would have to work out, okay, how many hours have they worked each week? And we should keep a record of that. Now we know what they paid in the month. And so what we can do is we can say, okay, we have a monthly pay period and they paid £800. They worked 40 hours. And so they're entitled to the average hourly pay is £20 an hour. And then we can work out what that would look like on average within the weekly worked hours, because you might change hourly pay for every year, especially if they're on minimum wage. In April, they always go up. So you're going to have 2 different weekly wages, and that might happen throughout a month, and it gets all quite complicated. So the way it would work is you still need to keep a record of their weekly worked hours, so we can work out their weekly average pay. And that will then give us, hopefully, a period of 52 weeks of hours worked within those weeks and how much they would have been earning in those weeks. And as I said, the way you would do that is by looking at how many hours they worked over a month and try to work out what their weekly pay would have been like within that month. It's not straightforward, but the other way to do that is just to actually keep a record for every week they worked, how much they would have earned in that week. So you're looking at the hourly rate versus the hours that worked in that week, and then we have a number every week. And then again, when we get to the 52-week period, we know what the average weekly pay is.
Okay. How do you calculate leave for a part-time worker who's changed their working days part way through the year So going from 5 days a week to 1.5 days a week.
Yeah. So you would have to make two. You have to do two calculations essentially. So you calculate from the start of the leave year to the point where they changed their hours or their days, and look at the proportion of leave they would have accrued in that period. And then similarly, what you do is you look at from the day they start a new arrangement to the end of the leave year, how much days they would accrue in that period based on the hours they work or the days they work. And you add the two totals up, and that gives you the total entitlement for that year. And then obviously you need to work out that they take the correct amount. But that's how you would do that. You would work it out, beginning of the leave year to the point of change, how much have they accrued, and then from the point they've changed to the end of the leave year, how much would they accrue there? Put the two together, and that gives you the total leave for that particular year.
Can we get copies of these slides?
Yes, we'll make sure they're in PDF format. And as I said, I would imagine we have email addresses for everyone that joined us.
Yeah.
So we can send those to you by email.
Okay. What about the opposite of term time only? So employees who work almost full time over the school holidays, but only a few hours per week during term time.
So they're working 52 weeks or equivalent of a full year, I would imagine in that case. In which case, I mean, it would all depend. So it depends on the contract, because sometimes what happens is it's a full normal contract, permanent contracts, and actually it's not necessarily term time only because they are working throughout some holidays, except that it's at reduced hours. In which case, most likely, because we'll have to see the contract, of course, but most likely the normal rules would apply. So again, it just the 5.6 rules would apply because they work full year. And you can still stipulate that they have to take annual leave in the periods where the school term is not active. So that will be a normal contract most likely. I mean, if it's a term time only contract and then you offer outside that contract additional hours, well, then the term time contract rules would apply. So again, a 5.6 weeks on that, and then it would all very much depend on what arrangement is put in place for the weeks they work through the summer holidays. I mean, if it was me, I would put it all in one contract so it's clean. But I couldn't give you a straight answer on that unless I actually see the contract to what the rules are and how you've set it up.
Okay. How often do you calculate 0 hours staff leave, weekly, monthly, or annually? Does the leave need to be included in the averaging?
So the way you would calculate is every time someone books essentially annual leave. So if someone says, I want to take 2 weeks leave at this date, then immediately before that day, we'll work out 52 weeks of average earnings, and that's what they'll be getting for those 2 weeks. And then if they take 2 weeks later, 6 months later, if they take another 2 weeks, then we'll do the similar thing over there. So we'll always go back 52 weeks. To whether annual leave weeks should be included, I mean, technically they don't work in that week. So it's a very good question, actually. We haven't really looked into that, but I would say it doesn't, because it requires worked week only. But what I can do, just on that question, I'll double check that, and then again, what I'll do with the email that we sent to you with the PDF and the links, I'll put some clarification on that, on the annual leave, whether annual leave weeks are included in the average as well.
What happens if the employee moves from part-time to full-time with a new contract part way through the leave year?
Yeah, so that's similar to the previous example of someone going from 5 days to 1.5 days. So again, we work out the entitlement from the beginning of the leave year to the point that they change from part-time to full-time. So we know what that is. And then we work out the entitlement from the day they start the full-time hours to the end of the leave year, put the two together, and that will give us the annual leave entitlement for that particular year.
If an employee has not taken their statutory leave and asks for a payment instead, is that okay?
No, it's not okay. Because again, it would be seen as encouraging employee. By that very practice, it would be seen as encouraging employees not to take annual leave. Because once that becomes known, other colleagues may say, well, hold on a minute, I can, I would benefit a lot more from an extra 2 weeks payment than actually going on annual leave. So they might just then save up all the annual leave to get that payment. So the answer is no, that's not okay.
Is it okay to calculate part-time holiday in hours and full-time in days, so long as the entitlement is the same?
Yes, and in fact, in the previous organization, that's what I did. I worked for some employees that worked out their annual leave in hours because they worked variable hours for the week. And for some, I worked it out in days because days at the end of the day, if you're full-time, is a lot easier to manage. So that's perfectly okay, provided that, as you said, the entitlement is exactly the same.
Okay. Referring to the part-time question where somebody works 3 days a week, do you not work out part-time green leave? Example, what proportion of bank holiday leave that part-time person should have?
I'm just trying to think about the question here. So what I think you're asking is whether we need to work out someone's annual leave proportion and bank holiday proportion. Is that what the question is?
Shall I read it again?
Yeah.
So referring to the part-time question earlier, where someone works a 3-day week, do you not work out part-time green leave, e.g. what proportion of bank holiday leave that part-time person should have?
Well, okay, so it all depends again on your contract. So from a statutory point of view, say that you only pay 28 days annual leave to a full-time employee, because bank holidays are not a statutory entitlement in itself. When you have a part-time employee, you just work out the proportion of those 28 days. It doesn't actually matter from a legal perspective how many of those days they needed to book off as annual leave to cover a bank holiday. So in the unfortunate event where someone works 50% of the hours, so they get entitled to 50% of the leave, and they always work in 1 year on every single bank holiday, it just happens that all the days fall on the bank holiday, it's really tough. They need to book off those 8 days if that's what is required of a full-time employee as well. And of course, that takes quite a bit of their entitlement because they're only entitled to 14 days. So they only have 6 days left and take the rest of the year. Now, the way around that would be to kind of be compassionate to the employee and say, well, look, we understand that's a bit of an unfortunate situation. To help you out with that, why don't you work an alternative day that week so that you can bank that day annual leave for a different time of the year? That's the literally the only way around that. Sometimes what we do see though is that employers offer annual leave in addition to all the bank holidays, and some employers still offer the full 8 days to employees who are on part-time hours. But that's not ideal because that means that sometimes a part-time employee may lose out and sometimes an employee may actually get additional days. Now, the additional days is not so much the issue, it's the one where they missed out on bank holidays because they're not working on the bank holidays. So the best thing to do would be to just look at your total amount. Even if you pay enhanced leave, look at the total amount. So if you give 28 days plus bank holidays, and someone is essentially receiving 36 days annual leave, at that point, you then make a proportion. So if someone works 50% of the working week, they're entitled to 50% of that 36 days as annual leave. The bank holidays in itself, in that case, doesn't matter because they're entitled to the equivalent amount of annual leave. So that's how that would work. Yeah, it is unfortunate if someone always works on bank holidays, as I said, but there's a way around that if you can facilitate it.
How do you calculate a part-time employee who works 3 days at 6 hours and 2 days at 3 hours?
Well, I probably would. Well, again, so there's 2 ways around this. So one is obviously you look at the total amount of hours they work per week, and that will give you the proportion of leave compared to a full-time colleague. The other way around would be to say, okay, well, they're working 5 days a week, so essentially, from a day perspective, they're entitled to the 28 days or whatever equivalent is that you offer within full-time employees. But for 3 days, they only paid whatever was the 6 days, and the other 2 days they get paid the other rate. But you would need to make sure your systems can run that. Again, we used to work with a system that actually allowed us to put different hours in for different days. And so whenever an employee booked a day off, because it was always fixed, the system would work out how much annual leave they had to be paid for those particular days. But the alternative is just to do hours. So work it all out in hours, and then there is less risk of getting it wrong if you don't have a particular system that can help you with that.
Okay, I think this is the last question. If an employee joins halfway through the year, do you need to wait 52 weeks before knowing how much to pay for holiday weeks? We would need to give them holiday at some point during the year, but we wouldn't know average weekly pay until they'd worked a full year.
So this is where you don't have a 52-week reference period. So what you need to do in that case is you work out. So if, for example, they are 3 months in, and they worked 10 weeks, some of the weeks they haven't worked, then your reference period is 10 weeks. And so you would work out the average weekly pay over those 10 weeks. Once they've been with you for 8 months and they worked for, I don't know, 26 weeks, then the average weekly pay will be over 26 weeks. But the moment you have a reference period of 52 weeks, that's what it will always apply. Before that, it's whatever weeks they have actually worked, you can use as the reference period.
Okay, that's all the questions.